In the present case, the trial court took into account the documentary evidence as contemplated in the statutory provisions and returned a finding that the date of birth of the appellant was 19th October 1991. During the course of its judgment, the High Court could not find such conclusion to be vitiated on any ground. Age determination, inquiry contemplated under the JJ Act and the 2007 rules has nothing to do with an inquiry under other legislations like entry in service, retirement, promotion, etc. There may be situations where the entry made in the matriculation or equivalent certificates, date of birth, certificate from the school first attended and even the birth certificate given by a corporation or a municipal authority or a panchayat may not be correct. In the face of the relevant documentary evidence, there could be no medical examination to ascertain the age of the appellant, and as such, the consequential directions passed by the High Court were completely unwarranted. Further, if the allegations of the prosecution are that the offence under Section 376 IPC was committed on more than one occasion in order to see whether the appellant was juvenile or not, it is enough to see if he was juvenile on the date when the last of such incidents had occurred. The trial court was therefore justified in going by the assertions made by the victim in her cross-examination and then considering whether the appellant was juvenile on that date or not. The learned counsel for the respondent, however, relies on the decision of this court in Karthi Supra. In that case, the accused had repeatedly engaged in consensual sexual intercourse with prosecutrix on different dates on promises of marriage. After having found that the promises were false, the prosecutrix had lodged a complaint asserting her exploitation on certain previous dates. While considering the delay in reporting the matter to the police, this court found that it was only after the accused had declined to marry the prosecutrix that a different dimension came to be attached to their relationship, and thus there was no delay in registration of FIR. The decision in Karthi Supra stands on a completely different point and cannot be pressed into service to say that because the appellant had refused to marry the victim, the date of the offence under Section 376 would consequently change.